Every single time you go online, you're leaving behind this trail, a kind of digital ghost of everything you do. But here's the question. Who gets to see who that ghost really is? Well, we're going to dive into a massive Canadian Supreme Court case that tackles that head-on, a case that totally changed the game for your digital privacy. Let's get into it.
Think about it. We all kind of feel it, right? That little bit of anonymity when you're just browsing or clicking around. But is it actually real? Well, the case we're digging into today, R versus Spencer, it basically puts that whole feeling on trial. And believe me, the answer it came up with affects every single one of us online in Canada.
Okay, so to really get this case, first we've got to talk about this idea of a digital fingerprint. See, every single device hooked up to the internet gets what's called an IP address from your internet service provider. You can think of it, well, maybe less like a fingerprint and more like a mailing address, but for your internet connection.
Right, and this is where it gets interesting. The cops can see the online activity, and they can link it to an IP address. That's kind of like seeing a car pull into a driveway. They can see the house, they know the address, but they have no idea who's inside. So the big, crucial question is, to find out who's in that house, can they just, knock on the landlord's door and ask? Or do they need to go get a warrant?
And that exact question is what brings us to the R v. Spencer case. So here's how it all started. Police were investigating some pretty serious criminal activity. They found someone using a file-sharing program, you might remember this one, LimeWire, to access and share child pornography.
So let's break down exactly what the police did. First, they spot the illegal activity online. Simple enough. Then they trace it back to one specific IP address. But here's the kicker. Instead of going to a judge to get a warrant, they just send what's called a law enforcement request straight to the internet service provider, which in this case was Shaw. And they ask, hey, who's the person with this IP address? And that right there, that decision to skip the warrant, that's the moment this whole case explodes. And guess what? It worked. Shaw, the ISP, just complied. They handed over the subscriber's info. And just like that, police had a name and an address, which pointed them right to a guy named Matthew Spencer. Okay, so the police have their guy, but was the way they got him actually legal? Did that little request, done without a warrant, actually violate his constitutional rights? This is where the real fight begins. It's a classic showdown, really, policing versus privacy in this new digital age. So you've got two totally different ways of looking at this. On one hand, you have the police. Their argument was pretty straightforward. Look, all we asked for was basic stuff, a name and an address. It's just subscriber info, no big deal. But Spencer's side, they saw it completely differently. They argued it was a huge deal. They said that request tore away the curtain of online anonymity, connecting a real, living person to what they were doing privately online.
Now, this whole thing boils down to a super important legal idea called the reasonable expectation of privacy. It's pretty much what it sounds like. If you can reasonably expect something to be private, then our Charter of Rights and Freedom says the government can't just come in and search it without a good reason. So the question for the court was, did Spencer have a reasonable expectation of privacy when it came to his name and address held by his internet provider?
And the Supreme Court came back with a really powerful answer. Justice Cromwell, who wrote the decision, basically said, hold on. This isn't just about a name and address. He said the real thing being searched for here was the identity of the person connected to all that specific internet activity. They weren't just looking for an address, they were hunting for the person behind that digital ghost we talked about. So, with the court making that huge distinction, the stage was set. Everyone was waiting for the final ruling, and you could just feel it. The entire world of digital privacy in Canada was about to get a major shakeup. So, here it is, the big question. When the police ask a company for your information, does that count as a search in the eyes of the law? What do you think, yes or no? The answer? A massive, crystal clear yes. The Supreme Court ruled that yes, asking for that info is a search. Why? Because we as Canadians have a reasonable expectation of privacy in that information. It's protected. And honestly, this next part is the real game changer. For the first time, the court officially recognized that being anonymous online is a key part of our privacy. Justice Cromwell literally said that anonymity can be the foundation of our privacy rights. This was just huge. It meant the law finally caught up and said, yeah, you have a right to exist on the internet without the government being able to easily figure out who you are.
All right, so the search was unconstitutional. That means the case is over, right? The evidence gets thrown out, Spencer walks free. You'd think so. But this is where the story takes this really interesting, kind of weird legal twist.
Nope.
The court did not throw out the evidence. And you're probably asking, why not? Well, their reasoning was that back when this happened, the law was super murky. The police were basically just following what they thought was the procedure. They were acting in good faith. And the court decided that tossing the evidence in this one case would actually be worse for the justice system than letting it in. So the bottom line is Spencer was still convicted. But, and this is the important part, the rules for every single police investigation from that day forward were changed for good.
So what's the big takeaway from this whole digital ghost story? I mean, why should you care about some court case that's over a decade old? It's simple, really. This case is the reason you have the digital privacy protections you have today. It basically built the fence around your online life.
I mean, the impact of this case is just huge. Thanks to R.V. Spencer, the police can't just go ask your ISP for your info anymore. Period. They need a warrant. Your right to be anonymous online, that's now a recognized part of your constitutional rights. What this ruling did was force a whole new balance between what law enforcement needs to do and what your rights are as a private citizen online. It set a giant precedent for how our old school laws have to keep up with new technology.
Look, the digital ghost case was a defining moment, for sure. But technology, well, it never stops moving, does it? The court drew a line in the sand back then, but now we've got all these new questions popping up about data, AI, surveillance, you name it. So while this case answered one massive question, it leaves a big one for us to think about. As our lives get more and more digital, where do we draw the next line?